right, welcome back to our business law presentations on the PowerPoint. We've now done test number 3, so we're moving into our last test number 4. Hopefully things went a little bit smoother this time via Moodle, adding that other bit of time, and I'll get you guys all your grades here, and I'll send out an email to you all kind of letting you know where you currently stand in the class. So you'll know whether or not you want to do that extra credit paper and kind of where you're at. So, all right, good job on kind of staying with it and having the fortitude with this weird sort of time. All right, so we have gone over and learned about the legal system, how the court system works, common law, statutory law. We've talked about how you start a business, the different types of businesses, and how to stay out of trouble so you don't get sued for a tort action. And we just did common law contracts. So now we're moving into the Uniform Commercial Code, which is essentially contracts again. Don't think that what we just learned, that contract section, common law, it's really similar. Just the UCC has some of its own rules on adding terms and isn't as stringent as common law rule. For example, the mirror image rule kind of goes out the door so long as you have quantity and there's an intent to contract. Court will usually figure out a way of making a contract under the UCC. Right, and then the last thing we'll get into in our last segment next week is going to be if your business just doesn't work, it fails or it's not working right, bankruptcy and how the bankruptcy code works. We're also going to talk about individual bankruptcy so you all understand kind of how it works for you if that ends up happening for you in the future. Hopefully not. Hopefully because of this class and everything else you've learned at Pacific University, everything will go peachy keen and there won't have to be any worry about bankruptcy. All right, so we're going to talk again about Uniform Commercial Code. So Chapter 21, Introduction to Sales. All right, so the takeaway for you all should be that the UCC helps merchants form contracts quicker and easier than common law. That's why the UCC really developed. However, with that ease comes some greater responsibilities. You're going to find that in the common law area of items, then courts are really going to look at the mirror image rule, really look to make sure all the terms are definite, et cetera, et cetera, et cetera. Now, under the UCC, there's a lot more flexibility. So that means the responsibility comes, you need to know what those rules are under the UCC if you're dealing with goods, because you may be getting yourself into a contract thinking the common law rule wouldn't, if those were applied, you would not have a contract situation, whereas under the UCC, you do. All right, so the history of the UCC, it did definitely start with the common law, and you can see there's still some items. For example, in the UCC, it still requires a written contract for goods over $500. So you can see some of the common law themes still running through the UCC. But with the common law, essentially, things were still complicated. It was hard for people to form contracts. The distances made it difficult to get a contract going because it may take a rider or the postal, if it was the old Pony Express or something, days or weeks or something to get an item of communication back and forth for people doing business. So it made it difficult to do so. So folks. And it was actually folks in the university profession that sort of started to think, we think there are better ways of going about this. But even back a long time ago, there was what's called the Lex Mercatoria. It means the law for merchants. There was already a change in merchants realizing they're different than perhaps, say, the sale of land or something of that nature, that there was we needed to have easier ways for them to do business and more assurances when they do business. And so merchants got together and created their own Lex Mercatoria, their own laws regarding how they would interact with each other that the court started to uphold as those were contract agreement types of a thing, right? And it focused on the agreements and the contracts for the sale of goods. Then 20th century, still started to see problems emerging. Again, we have greater ability to move goods to larger distances. but that distance sometimes made it, obviously, to a handshake makes things difficult. So we saw these sort of problems starting to emerge in the 20th century. So the old contract laws just didn't reflect what people wanted or were trying to do in the modern law practice. And sometimes they were just doing it, and then if they sued, they'd have to use the common law, but they were just going to do things differently anyways, and kind of making side agreements, if you will. Laws from each state varied, widely varied, right? And sometimes it was because states wanted to have, the better state for people to be doing good, so they would make their laws more favorable. Well, then other people that were producing in other states didn't want to deal with people in those states sometimes. So again, because those laws varied, it made it very difficult sometimes to do business across state lines or even across different countries. So the UCC emerged and began to be adopted by all the states and the federal government. It was developed, again, by those at the universities who then took it to the legislatures, and then basically every state has some form of the UCC in practice. Not all. Most states have, the majority of 90+% of what the original UCC was, but states vary some things here and there. Not much. All right, Oregon Revised Statute, Chapter 71 and 72 are the general ones that deal with the UCC under Oregon laws. All right, I don't want you guys, just want to make sure I put them in here. Article 1, Section 102 is what that little two S's sorted together stands for. Backward S's, I should say. No, they're regular S's, sorry. I don't need you to know or memorize the numbers of these particular chapters. I don't want you to do that. I just want you to kind of have an idea of what the UCC is about and what it says. So you don't need to memorize Section 1, 102, where in this particular case it talks about the UCC where it should be liberally construed by the courts, right? And applied to promote the underlying purpose of forming contracts, allowing businesses to exist, and the sale of goods to really be fostered. That's what that section is. Again, don't remember the numbers. Just remember that the UCC is all about being liberally construed to form contracts when it comes to goods. Yep. The underlying purpose is to promote business transactions and to get the right results, right? Remember, sometimes in the common law area, there was some draconian results that would occur. And so the court started to kind of carve out these different types of exceptions or ways around those draconian results, right? There was the promissory estoppel, quasi-contracts, injunctions, those kind of things, remedies that really were equitable remedies because the draconian way in which we were supposed to interpret contracts was creating these draconian results. So the UCC is different than that. Not only is it trying to promote businesses and the sale of goods, it's also trying to have a good outcome for everybody, or a fair outcome for everybody. And it's going to, again, create that contract when possible. All right. The purpose of the UCC is also to simplify, clarify, and to modernize commercial transactions when it comes to the sale of goods. All right, permit continued expansion of commercial practices through custom usage and agreement of the parties. Again, you will see sometimes when we go through some of these rules that sometimes the court's going to take a look at what's the industry standard. If the parties can't agree on something, or if the parties say we want industry standards, then the court has to use industry standards. And if the parties have a relationship with each other and have a past relationship with each other in the exchanging of those same goods, the court's going to use that relationship to fill in any terms that may have been left out in a recent contract, right? And then again, we're trying to make things more uniform across different jurisdictions, not only from county to county, but from state to state, and to some degree from country to country. That's a little bit more problematic, but even in that area, we're trying to do that. What you'll see is not in Article 1, but additional purposes is requires sensible and ethical good faith behavior, right? It doesn't specifically say it, but it implies it clearly throughout. There are some places where it does talk about good faith, but certainly being reasonable with other folks and being ethical and good faith is certainly things that are implied in the UCC, and certainly what the courts, when it imposes the rules in the UCC, is trying to do. Another thing I want to make sure you guys talk about, and there may be a question on the test on this, maybe an extra credit question, is the three takeaways from my class. All right, 1, no single test will ever define your entire life. Remember that. 2, good faith is always required in business transactions. It should be required in everything you do in life, but certainly it's required in all business transactions. And 3, when presented with an ethical dilemma, do the right ethical thing. All right. All right, hopefully get those technical difficulties taken care of, and we can kind of move on here. We've gone. All right, hopefully get those technical difficulties worked out, but it's going to continue to happen. All right, so I put up this little slide because I think it's a good way for you all to take a look at. You know, I'm kind of a visual person, and I think this does a good job of helping you out regarding Article 2 regarding the sales, and that's what sometimes people refer to it as the Article 2 is the sales provision. All right, governs contracts for the sale of goods. It preempts common law. If there is regarding a sale of goods, then the courts are going to look at the UCC and not at common law rules. It is not. If it's not in the contract to apply the UCC, the court will still do so unless specifically it says we're outside of that, right? And if the UCC is silent, then the court will take a look and use common law rules to make any decisions. All right. So mixed contracts. This is what we talked about, whether, because sometimes you're going to have to, as a court, decide, all right, is this a sale of goods, or is this a, for example, service contract, right? We'll get into you being the judge here in a little bit as one of those, how do you decide which it is? But the courts are going to look at and say, all right, if there's a situation in which a contract involves both the sale of goods and a service, for example, remember one of those stories I've been talking about, my daughters are getting married and I contracted 15 months earlier, or if it had to be in writing, for some chairs, right? Well, as part of that contract, the company is also supposed to lay out those chairs, right? Well, that's a service, right? Laying the actual chairs out. But the actual, rental of those chairs is a goods type of a transaction, right? And so that's how do we define and how do we work out the two of those? And or in my scenario, is a rental, is it just all a service or not, right? Or versus if I purchase those shares. All right. So what the court has to do in situations in which it's trying to figure out if it's a contract for goods, the sale of goods, or if it's a contract for service, which one is the predominant purpose, right? If the predominant purpose is the sale of the goods, right? I'm buying those chairs, let's say, and they're agreeing to lay them out, though, at the wedding. Well, then the primary purpose is goods, therefore UCC would apply. If it is a rental contract and I am renting the service of them coming out and laying the chairs out for me versus buying anything from them or something like that, then the predominant purpose is a service, therefore common law applies. And that's what the court has to do. And sometimes that's the arguments as an attorney you have to make. Was this, right? I'm going to argue that this was a sale of goods, therefore UCC applies, and therefore this is what you should do, court, under the UCC, versus I'm going to argue to you, judge, that this is a service contract and therefore common law applies, and therefore this is what you should do, judge, right? That's kind of what attorneys do, is we're going to make an argument as to why it's a service or why it's a sale of goods, and therefore which provision applies, which is beneficial to their clients. All right. Common law will govern if the predominant purpose is for providing a service. All right. Now, under the UCC, here's what the court's really looking for to determine if somebody is, if the parties, I should say, are forming a contract, right? And I've kind of prefaced this that there's 3 ways to make a quick and informal type of contract under the UCC, which is very different from common law, right? So under common law, right, there was the mirror image rule. Here I have an actual offer to you. You have to accept exactly that offer that I have given to you. Both of us have to have consideration going back and forth, right? It has to obviously have been legal, everybody has to have capacity, and in some instances there has to have been some sort of right, right? Here, we're just going to look for any manner in which the persons have shown some sort of agreement, whether it's letters back and forth or text messages back and forth, something scribbled down somewhere, but but maybe even a letter of intent, and sometimes can form under the UCC, right? Unless it's clear it's a letter of intent. But in some instances, you write, "Hey, I want to think about doing this deal for you," and I agree, let's do this, kind of thing. Those can be enough, right? Any kind of manner in which show agreement. The moment of making it is not critical, right? Remember, under common law, when you make the agreement has to have everything there, right? Offer, acceptance, consideration, everything has to be, it's all determined at that time in which you come together and I accept, kind of thing, all has to be. Here, not necessarily. There's going to be a lot of times in which there's correspondence going on back and forth in the mail or in text message or emails these days, and so that moment of forming or finding a contract is not critical. It can happen at a much later time for sure. One or more of the terms can be left open, right? Remember, under common law, all terms of the contract have to be present and definite, right? Under the UCC, as I told you earlier, so long as we have a quantity, just about every other element, right? If we can tell that the parties intended to have an agreement and we have the quantity, we can basically form and uphold some sort of a contract, right? There are ways in which the court can use either the UCC gap fillers or reasonable standards or standards between the parties, right? Times in which the parties have worked together and they've used a certain price when they've worked together, we can use that price going forward, right? So there's different ways so long as we have quantity. Quantity is the essential term that without quantity, the courts usually are just not going to find that a contract was formed. All right. There is something different when it comes to merchants versus, say, you and I, who are, if I go to Home Depot, I'm a consumer, right? I'm just a regular individual type of situation, or even businesses. They're individual businesses, but they're buying something from somebody who routinely deals in that particular good, right? One example I can give to you is if a person's business is to can tuna, right? When I got out of high school, I went up to Alaska and, kind of was working around Alaska, and we would sell the fish that we caught to the canneries around there, right? So in their salmon is what they were actually canning. So in that particular situation, the merchant routinely sells canned goods. But in order to get those canned goods out to the market, that owner had boats and trucks, right? But when that owner goes to sell those boats or those trucks, they're not considered a merchant because that's not something that they routinely deal in that particular good, right? So to understand, a merchant is somebody who routinely deals in a particular good that's involved in that transaction. When that's the case, they're held to a higher standard. They're held to a higher standard. So, example, in my situation, I'm talking about the owner of that cannery. When it comes to the sale of those canned goods, they're held to a higher standard. When it comes to the sale of the trucks or the boats, it's the same standard that would apply to you and me. They have a good faith and unconscionability and reasonableness standards, right? Everybody has to act in good faith, but they're held to a higher standard of good faith. They're held to a higher standard of unconscionability in the sense of if they have terms in their contract that really seem to be one-sided in their favor, the courts may declare that provision. Again, we're not going to necessarily throw the whole contract out. We're just going to find that particular section is avoidable provision and then use a reasonable standard going forward. Right? And then again, reasonableness means the idea of they can't do something, for example, you have to deliver to me in 10 days when it usually takes 20 days to make whatever you're trying to get to them, right? That's just not what's going to happen. Or you have to do something in a time in which it's just not reasonable, right? They're held to higher standards. The UCC imposes a duty of good faith in performance of all contracts. That's for everybody, right? But for them, it's good faith, unconscionability, and reasonableness. That's the differences between the two, right? For non-merchants, what that means is honesty. In fact, you can't lie or mislead. We all are held to that particular standard when it comes to dealing of goods. We have to be honest in our transactions. Merchants have to be honest in fact, right? No lying or misleading. Also have to exercise reasonable standards of fair dealing. They have to perhaps disclose, right? Even though in the honesty in fact, it doesn't mean I have to disclose something to you that might make you want to deal with me in a different way. I just can't lie or mislead you. But so long, I don't have to necessarily provide certain information. Whereas in merchants, if that's the standard of fair dealing is to let you know something, then they have to let you know something. All right. All right, let's get into one of our you get to be the judges here. We're going to try to see how the court would apply some of the rules we've just talked about. All right, so Jack agrees to sell his massage business to Jill. Jill is not sure how to do massages, but Jack tells her it's easy, and if she buys the beds, Jill doesn't know, he'll show her how to do the massage business, or essentially how to do massages. Jack's massage business consists of 20 beds, 4 trailers to haul the beds, and a bunch of boxes full of oils. Jill agrees to buy the beds for $250 a piece, the trailers for $2,000, and each of the boxes of oils for $25. Now Jack arrives at Jill's with the beds and 3 of the trailers, and Jill accepts all the items at that point in time. 2 months go by and Jack still hasn't been paid from Jill. He calls Jill and she argues, well, you told me you were going to show me how to do massages. I'm not paying you until you do that, right? Jack says, all right, that was not what I really thought we were talking about in this particular case here. Didn't think you were serious about me actually teaching you how to do that. So you need to pay me. All right. So Jack decides to sue for the $13,625. And the question really for you all is, does the UCC or common law apply, right? Again, is it a sale of goods, the predominant purpose being the sale of goods, or is the predominant purpose being for a service, right? You have both a sale of goods potentially in the trailers and the beds and the oils, and then on the other hand, you have him teaching her how to do a massage, right? Which would be a service, him teaching her how to do that, right? In this particular case, fairly easy as to what's the predominant purpose, right? There's a lot of oils, a lot of different things that are going on there, and the predominant purpose is, in fact, the sale of those goods, right? So the agreement regarding how to teach Jill how to do that. Now, that's something that the court might come back and say, although the UCC applies and predominantly going to apply in this particular case, we may use common law ways in which to say, yeah, we can understand why in this particular case Jill hasn't paid. We're going to make her pay, but to compensate her for the idea of she needs to learn how to do massages, we might do it one, do a specific performance. Remember, courts doesn't like to do that, which specific performance here would be requiring Jack to teach her because he might teach her wrong or badly. Remember, we talked about, right, specific performance, making an athlete have to perform. You know, that's just usually not what the court tries to do as far as specific performance goes. It's usually related to art, antique, some specific item, right? So we're not going to make Jack do that. Just not going to make any sense. Whereas what the court might do is require Jack to pay for her to go to a massage school. So deduct from the $13,625 whatever the amount of a massage school would be, and therefore compensate her in that way. All right. Jack will win the lawsuit. We talked about that. So let's move on to the UCC statute of frauds. There is a statute of frauds application in the UCC. Remember, again, we're still talking about the sale of goods. But remember, under the statute of frauds, the sale of goods over $500 means it needed to be in writing. The UCC is no different than that. It still has to be in writing. There has to be some form of writing. The difference is the mirror image rule, the definite and essential terms, all those things having to be in the writing itself is not required under the UCC. Okay, so we'll talk about that a little bit more. Same dollar amount, anything having to do with $500 or more is going to require the UCC. Sometimes I get people asking the question, well, what if each item is a $2 item, right? If there are 1,000 of those $2 or 250 of those $2 items, you're hitting $500. It needs to be in writing. It's whatever that contract is. If it is goods and it's over $500, it needs to be in writing. If it's under $500, then we've talked about it before, UCC still applies. It just can be done in an oral fashion. If it's $500 or more, some writing is required, but not all the details necessary to form a contract. All right, writing is only required to be sufficient to indicate that the parties had an intent to perform or form a contract. That's all the writing really needs to have. Remember again, it's going to require, obviously, that the defendant, i.e. the person who's being sued, has signed. That's that kind of so we can tell that they intended to do that contract, right? Usually they've had to have signed that or have some way of proving that, acknowledging that there was some indication that they wanted to form or be part of a contract. And we'll talk about some of the merchant's exceptions in this area as well. But so long as we have that and we have quantity, that's it. That's all that's going to be required, and those are in the writing, right? Some sort of intent to form a contract and a quantity, we're usually going to say, good to go, right? Defendant signing it, we're good. All right. Quantity, as I talked about, is almost always required. It's rare, but sometimes you may have a situation where there's a history between the parties in which the last 20 contracts they formed all were 100 goods, right? Then we could say potentially we can use that to say, all right, there's probably the intention to have another 100 goods again, right? But usually there's got to be the quantity involved in the writing, somewhere in the writing. For UCC statute of frauds, here are some exceptions. That means it does not need to be in writing, right? The merchant exception. This is the biggest one. Remember we talked about merchants are held to a higher standard. Not only held to a higher standard of honesty and fact and reasonableness, all those, they're also, this is where if you're not careful, you can get yourself into trouble and understanding that a contract will exist under the UCC. If you're a merchant, because we're going to understand that you have a higher understanding of what goes on in the business world, and therefore you should know what you're doing, and if not, it's on you. All right, so the merchant exception is when there are two merchants, right? Both people are dealing in a particular good, right? So we have two people that are both involved. They're both merchants. They're both sophisticated people. They make an oral contract, and one of those merchants sends a sufficiently definite confirming memo. Hey, great conversation I had with you on the phone. I would love to do that $250 deal that we talked about. Boom, we have a contract. Unless the other party comes back and says, no, we didn't complete that deal. We were talking about things, but there are some items that I'm not sure about. I don't want to have a contract, and they do that within 10 days of getting that first confirming memo. All right. In that situation there, if there's no objection and someone sends a confirming memo, then we are going to have a contract. All right. So think about it this way. There are two merchants and there's a confirming memo. One merchant, right? As long as there's no objection, 10 days, you're good to go, right? You have a contract. If there's a specialty goods, if a buyer orders a good that is specially manufactured for that buyer and really can't be sold to anybody else, right? Then a verbal agreement is generally going to be enforceable if it exceeds $500 and it's not in writing. In that particular case there, it's going to be pretty clear that, look, this is a specific item that only this person would need, and therefore that kind of helps us to get the idea that they intended to form a contract. Otherwise, why would this person make this specific item for this specific person that's special to them unless there was certainly some sort of intent to form a contract, right? And if somebody comes into court and says, I admitted I was forming a contract, even though it wasn't in writing, court's going to use that judicial admission and say that a contract wasn't formed, even though it wasn't originally in writing. All right, welcome back, and I have to apologize. You may not realize I left, but I had to go do some work, and this is actually a different day, hence the different shirt and different tie. So again, we're dealing with Uniform Commercial Code. We're in the introduction to sales, and what I want to talk to you about is added terms. Remember, when it comes to common law, added terms would be counteroffers, and therefore it would have to be, again, those counteroffers accepted under the mirror image rule by the original offeror, who is now the offeree. All right, but under the UCC, it's different, right? So common law, you have the mirror image rule. One party makes an offer, that offeree must accept those exact terms, otherwise it becomes a counteroffer. Under the UCC, an acceptance that adds or altered terms will still create a contract. The UCC just has a way to deal with either added or altered different terms, right? That's the kind of how it works, added or altered terms. Now, this came about by really the battle of the forms, right? You might have one business that says always in their standard forms, due on within 30 days of receipt, and the other one says delivery within 45 days, right? That kind of a situation, and the UCC said, look, we're going to consider that the parties always have to intend to form a contract, that they did so, and then we can deal with those added terms, and we can do so in a reasonable way. It's kind of what's going on there, right? So different. When it comes to added terms, first, did the parties intend to create a contract? If so long as they did, then we can deal with these additional terms. Terms that introduce, I should mention, additional terms are terms that introduce issues that were not covered in the offer, right? Different terms are those terms where the example I just gave says delivery within 30 days and the other one says delivery 45 days, right? Those are different terms. Here, maybe one says delivery within 30 days, the other is silent on when delivery has to occur. That, in fact, would be an additional term. All right. When it's between merchants, the additional terms are binding. Unless, here's the key. So remember, start with the premise. If it's between merchants, then it's binding. Say, for example, Toyo Tires was making tires for Les Schwab, and Les Schwab was purchasing tires from Toyo Tires, right? And the Toyo Tires, or the Les Schwab contract says delivery of tires within 30 days, and Toyo is silent in their form, right? In this particular case, because they're merchants, those terms would be binding on Toyo Tires to deliver those tires, within 30 days, unless the original offer insisted on only the original terms. So if in the original Toyo offer it said these terms and only these terms can be considered, then in that situation there isn't any requirement regarding the time in which those tires need to be delivered. So long as the original offer said only these are the terms you can accept. The additional terms don't materially alter, right? If it was in, say, Les Schwab's contract, it says delivery in 2 days. Well, there's no way Toyo has got to make them, whatever. There's no way you can get those tires there necessarily in those 2 days. Maybe the factories are too far, or factories in places, whatever. It would clearly change the contract in that particular situation, right? Especially if it said something along the lines, and if you fail, then you owe us $10,000 by failing to deliver on time, something of that nature, right? Then lastly, if the offer promptly objects to the term, if in fact Toyo were to come back and say, hey, we're accepting all this, but we specifically object to delivery on that 30 days, right? Or 3 days, whatever. In those situations, then there would not be, those additional terms would not be binding. Otherwise, they are binding. All right, different term. Remember we talked about additional terms, right? The original, nothing in the contract. One contract says something about that. The other contract is silent on that particular. Different terms are when they contradict each other. That's that example I gave earlier. Again, Les Schwab and Toyo Tires. Les Schwab says delivery in 30, Toyo says delivery in 45 days. Again, we're going to start with the idea that we have a contract, the parties intended to form a contract. Now we just got to figure out how do we deal with these different terms, right? So here's what the court usually does under the UCC. One, they just cancel each other out. That's what we're typically going to do, right? Because there was differences, they just cancel each other out. Two, we're still going to make sure they had a clear oral agreement, right? Or whatever it may have been, right? If there was no clear oral agreement on any of those matters, right, then we're going to use some UCC gap fillers. For example, there's a UCC gap filler that says something along the lines of reasonable time of delivery, right? And so we take a look at that industry, the tire industry, and we say what's reasonable from the time in which the people make the bargain, what's reasonable for tires to be delivered. Maybe it's 30 days, maybe it's 45 days, maybe it's 60 days. And we'll use that particular standard, market standard, to fill in as to when those tires should have been delivered. All right, modifications. This is different. So now we have situations, we had additional, we had different, and now we have modifications. So it's in the contract, but the parties want to modify, or a party wants to modify. The parties can say, look, any modifications to this has to be in writing. Say, for example, you wanted to send something that was a little bit different. Say, instead of a widget, right, you wanted to send a little knockoff of that widget, but it'll perform exactly the same way as the widget does, right? And your contract's silent. Maybe you can say, we're going to, instead of the widget, we're going to provide this for you so that you can, comply with your original contract because you don't have enough widgets currently on hand, something of that nature. Who knows? So parties can require any modifications to be in writing. If any of the contracts said all modifications have to be in writing, then they have to be in writing. So I would have to send to the company in which I'm selling widgets, hey, I've got these knockoffs. They basically do the same thing. Will you accept these as conforming goods instead of the widgets? And if they say yes, we're good to go. If they say no, we may have some issues. A UCC section makes this term invalid if other party is a non-merchant, right? Again, if it's between merchants, what I just indicated is right. If it's between non-merchants, then not necessarily, right? Unless that party agrees in writing to that particular provision, all right? So that's kind of how the UCC deals with modifications, right? Usually it has to be in writing if it's specifically stated in the contract. All right. I gave this, I'm blocking out my little picture image is going to be blocking out one of the areas here, but it'll be posted on Moodle, so you'll have an idea of kind of how this all works. You know how I am. I like to see things kind of this way. It helps my mind when I see the schematics, kind of get an idea. So the top part is where you begin in that particular situation, right? The offer makes an offer, right? So either if you go to what I'm looking at and what you would be looking at to the left, the offeree does not intend to accept, right? Then, as you see there, we've got no contract, right? If we go the other way, offeree intends to accept that, we have 4 different boxes. There are different things that can happen. One, they can accept terms as they are. Boom, we have a contract. We know exactly what that contract is based on those terms. We can accept with additional terms. We talked about a situation on the tires in which one person could have a delivery date on it. If they're both merchants, then additional terms become part of that particular contract, unless, as I've got there, those 3 reasons, right? There are different terms. It's generally a valid contract. Most states would still have that contract, but they cancel out those different terms, right? And then they use the UCC gap fillers as ways in which to, if that area is some concern, say for example, again we had the 30 and the 45 days of delivery, both those go away, and they're going to use the standard, maybe it's even 60 days, maybe longer, and they both may get a benefit, or one may get a benefit from that situation, or detriment, but we're going to use that standard, industry standard, right? If there's an acceptance and conditional offer sent to additional terms, then again, we have a contract. All right. So I've kind of got, remember, we're talking about those tires here. This is just another way of taking a look at it, where in the first scenario there, you have offer, and it's a mirror image. So you under the UCC or common law, we're good to go. And the other one, we've got an additional term, delivery within 60 days. As we know, since it's between merchants, it's going to be valid unless, in this situation here, there is a notice sent back saying, I don't want that or whatever. In that situation, we're going to not cancel that. We still have a contract, but specifically not the 60 days, then that term would go away. And then the last one there is where we have different terms. We're going to strike out the 5 days, the delivery days, and then set a reasonable standard under the industry for that. All right, that's called the knockout rule for different terms. Knockout rule. Remember that. Knock them out. All right. So let's get back to open terms. Parties may conclude a contract even if they haven't settled on a price. Remember, we've talked about before what I mean by open terms. I should have done a better job explaining that, sorry. Open terms may mean that we leave in the contract, hey, I agree to sell to you 100 widgets, and we don't settle on a price. I agree to buy 100 widgets from you, right? We're both silent on that. So we've left price as an open term. That's okay. Remember, the one thing that is very difficult to leave open is amounts, right? How many of something. That quantity is a difficult one for the courts. You know, the only ways in which you can do that is, remember, those types of contracts in which your output contracts, those kind of things, where it's everything you sell, I'm going to purchase from you, or everything you produce, right, those types of situations, right? Then under those, right, then you quantity may not be in there. We'll just figure out what you typically produce or typically sell. All right, so parties may conclude a contract even if they haven't settled on a price. No big deal. There's a whole bunch of different ways. We can use reasonable standards. We can designate somebody who will set those particular prices, some expert in that area, whatever it may be. But parties can conclude a contract even if they haven't settled on the price. If no price in the offer, then it's a reasonable price at the time of delivery. So if delivery is set out, maybe it's in the contract, delivery in 90 days. It's not going to be the price in which we entered in the contract. It's going to be the price at the time in which I delivered. So if goods can go up in that time and you don't settle in on a price, you may end up being in a difficult situation 90 days out for some reason. Some catastrophe occurs, something for some reason, shipping costs or whatever, somebody could be in an awkward situation where they're not going to make as much money as they originally thought earlier. But that's your choice by leaving price open at that time. Parties can agree to have the price fixed per market or other standards. So again, that's where you can basically say, here's what the market standard is, that's what we're going to use. Parties can agree to have a third party or an agency set the price. Sometimes there are agencies out there. There's a lot of times when it comes to commodities, there's agencies that set those commodity prices, and so we can say we're going to use that index to set our particular price. Parties can agree to have one of the parties set the price. Now, if that occurs, remember, always they have a good faith duty to set a price at a reasonable level. Caveat: if contract specifies no contract, if parties can't agree on price and they don't agree, then you have no contract. Again, that's a weird situation, but it certainly is in certain contracts. Purchaser would have a good faith duty to return the goods or return what is reasonable they can in a good faith manner. All right, reminder, as always, you can see I've got it in there, but good faith is always required in all dealings by both parties, whether it's common law or UCC. All right, here's what I was talking about earlier with price, what are called output and requirement contracts. Output contract is a contract in which the seller agrees to sell everything it makes to the buyer. Say, again, going back to my example with Toyo tires. Say Toyo tires and Les Schwab agree that all tires produced by Toyo will go to Les Schwab, right? They want some exclusive type of a situation. And so we agree in that situation that all tires produced by Toyo will go to Les Schwab. So if I'm Les Schwab, that may be a difficult situation because I'm agreeing to buy any and all tires they make in that situation, right? That's called an output contract. A requirements contract is the buyer must purchase all goods that they needed goods from the maker of those particular goods. Trying to think of a good example there. Say I'm a news paper company, and not that newsprint is used much anymore, but I want to get some newspaper, right? A place who makes all of the paper, right? I, as a New York Times, would have to go and purchase all of my goods from them. So I agree because I want to make sure I get paper. I don't want to screw around with fluctuation of prices or whatever. I agree. I'm going to go only to them and buy my paper only to them, right? And that company's agreeing to make sure they're making enough paper for me. That's called a requirements contract. Parties must make their demands for either outputs or requirements in good faith. So, for example, Toyo tires, say they make 100 tires a week, and so I'm Les Schwab. I understood I'm going to be buying 100. Well, all of a sudden they make this contract, they start making 1,000, right? They decide to put in the factory and they make 1,000. Well, you're not acting in good faith. I, as Les Schwab, thought 100 is what I'd be getting. Now you're at 1,000. I can't sell 1,000 tires, so that's not acting in good faith. Whereas, same thing, there's requirements contract. All of a sudden, if you were New York Times or whatever, you can't be asking for more paper than you originally needed, right? All right. Parties may change, alter the output requirements so long as they're doing so in good faith. They could go up. So if you're Toyo tires and you're doing 130 tires this week and 190 tires the next week or whatever, that's okay. That's still, you're good to go. There's a great table at the end of the chapter that kind of outlines a lot of these areas, and so I highly encourage, on page 494 of the book, highly encourage you to go take a look at that. That kind of goes through all this information. All right, so that's the end of chapter 21. Now we're going to be moving to the warranty section in the UCC. Where we talk a little bit about warranties, strict liability, and some other stuff on torts, and some other stuff, and product liability and product warranty, those kind of things, right? But this is how goods are going to be warranted under the UCC. There are what's called some implied and expressed, and we'll kind of go over those. Anyways, so we're moving from chapter 21 to now chapter 22. You're wondering, why do I got these two cups there? Well, I remember in the book it talked about Starbucks being sued, and I always think it's kind of humorous when I saw it there being sued, because I always go in, I order small, medium, or large, and it's like, grande? And I'm like, well, is grande a large? No, that's a tall. Anyways. So warranties is a contractual assurance that goods will meet certain standards. In other words, it's a contract, right? If your goods don't meet those standards, then you have breached your contract with whoever's purchased those goods. Warranties can be expressed by words or actions. I warranty this paint to last for 20 years, right? That would be an express warranty, and that paint should last for 20 years. If it doesn't, you are in breach of your expressed warranty. It's an affirmation of fact or promise. It can usually be proven, right? You could tell in my scenario there regarding the paint, if in 20 years the paint's not still there, you have a pretty good understanding that it didn't work and it failed the warranty. You can do so by description of the goods, and you can do so by a sample or a model. In other words, these are all different ways in which you can create an expressed warranty, right? You can make a promise of fact that something will or will not occur. You can describe the goods will be a certain way, or you have say if you're in Costco, right? Now sometimes with the blenders, they have a person in Costco running those blenders, and look, it'll slice and dice and do all these things, and right, that model that they're using and showing you, they're agreeing that that's exactly how when you buy their product, it'll work when you get it home. Now, plaintiff is required to prove that the warranty was part of the bargain, right? So they're going to have to say, for example, I go into the paint store, go into Miller Paints, and I say, hey, painting my house again. I need a paint that's going to last for at least 10 years. And the guy said, oh, yeah, right here. We got this paint right here. It's definitely going to last for 10 years. I'm going to have to prove that he told me that it was going to last 10 years, right? If it's a he said, she said sort of a thing, I may not win that particular case. It's my responsibility to prove it, right? I probably should get it in writing. Hey, can you write there on that sales receipt, agree that this will last for 10 years kind of thing? Then I've got it clearly expressed, and I can easily prove that it's indicated that it would last, an express warranty that it lasts for 10 years. More likely to be considered warranty if there is an affirmation of fact or promise. Again, not some salesman puffery. Oh, this is the best paint ever. People tell us it lasts forever, kind of a thing. That they've painted it once and they just don't have to repaint it again, right? That is not something that can really be measured. That's considered salesman puffery, right? They're not going to be able to usually use that as an express warranty. Statement specifically and can be proven, tested, or verified. We've talked about that. If it's in writing, such as a brochure, right? Sometimes Miller Paint may have a brochure, and the brochure may say it lasts at least 10 years. Well, then that's an express warranty. And in that situation where I'm going to Miller Paint, they're supposed to be the experts since they're selling Miller Paint. So if they've got greater expertise, they should know better, and that's another way to prove that it was in fact an express warranty, right? And if there's a description of the goods, right, that paint will last for X amount of time, it'll be glossy and it'll last forever and it'll be bright or whatever, right? Those are ways. Again, we've talked about the sampler model at your Costco store. All right, implied warranties. So we had express warranties where it was stated. Implied warranties mean nobody has to say anything, but we are going to, under the UCC, when it comes to goods, agree that you sell something, these things are implied in that sale. Again, this is created by the UCC, not by any act or statement of anybody actually selling any goods. It was just the UCC saying, look, if you're going to sell something out there, these are implied warranties that you have to deal with. One, there's the implied warranty of merchantability. It's goods are fit for the ordinary purpose in which they're sold, right? So on my paint scenario, that that paint will work as an ordinary purpose painting a house, right? It's going to work for that. In other words, I painted on my house, and the first rain comes and it washes off. The implied warranty, even though nobody told me it was going to, whether it was or wasn't going to be washed off the house, right? Didn't ask question. I just went in, I got house paint, painted my house, first rain, it goes away. Implied warranty of merchantability is that was the intended purpose. It wasn't supposed to wash off, right? So I'd be able to sue the maker of that paint. Merchants routinely deal in that specific goods. In my paint scenario, that's what they do. They do paints, right? Or they hold off, right? In that situation, I not only sue Miller Paints, but I also sue the people who sold Miller Paints who told me all those items, right? Merchants can exclude or modify implied warranties, right? So you many times, for example, I just bought a new vehicle, and although it's only a year old, there still is you're buying this as is type of a scenario, right? So they can exclude or modify implied warranties, and we'll talk a little bit about that here in a second. So implied warranty for a fitness, for a particular purpose, right? The here is at the time in which you and I reach an agreement. You know, I've told you, hey, I need to have this paint last for 10 years. And you're like, oh yeah, yep, that paint will last for 10 years, right? even if you don't say anything. If it's an express because you tell me, but I tell you I need a paint that'll last for 10 years, you go, all right, let's come over here. Let me show you these paints. And I show you the paints, but I never tell you anything. I never say it'll last for 10 years, but you know exactly what I want it for or need it for. In that situation there, that's called an implied warranty of fitness for a particular purpose if it doesn't last as we intended it to last, right? Keys. The merchant's aware of the purpose. The seller, all right, or the merchant has particular skills in that area. And there is no specific, again, you're buying as is or implied warranty of fitness for particular use is excluded or whatever may be in whatever contract we end up coming up with, right? Warranty of titles, right? So this is, if I'm selling something in which there is a title to, I'm warranting under the UCC, or it is warranted, that I have valid title of those goods that I'm selling to you, that there's no security interests on that unless I tell you otherwise, right? So that's the idea, is if something is required to have a title, I sell it to you. The idea is it's clear and free and no security interest attached. A disclaimer is a statement that a particular warranty does not apply. So again, we've talked about express warranties. We talked about the different types of implied warranties, warranty of title. Well, we can disclaim those to some degree. Under the UCC, a seller can disclaim an express warranty or a UCC implied warranty. So maybe if I'm Miller Paints, I want to put in my contract any express warranties by the seller are disclaimed at this point in time, right? Key, it generally needs to be clear and inconspicuous. And under the FCC, an implied warranty must also mention merchantability. In other words, that word just it's a weird, screwy thing, and you can see I don't have it, that you really need to worry about it. But the word merchantability has to be in there in that disclaimer. Don't know why, but that's how the UCC deals with it. You'll see things as is, sold as is, or without faults, or whatever. Those are ways and other ways in which people can disclaim a particular warranty. They are heavily disfavored when it comes to consumers. So my scenario about the paint, the disclaimer of express warranties probably is not going to fly with the court in that situation, or as is, or whatever, or just because I'm a consumer. But maybe if I was a painter and that's what I did for a living, then they may allow that disclaimer to take place. All right. Remedies. All right, so under remedies for limitations is parties can contract to limit remedies if a breach occurs, is what the UCC allows for. So it could be if a breach occurs, any damages are limited to consequential damages, right? It could be limited to just your out-of-pocket expenses, those kind of things, which is what consequential damages are, right? If a buyer is a consumer, courts generally won't honor any remedies of this type. It's just likely to be considered void, unequal bargaining power type of a situation. Certainly voidable if an injury occurs, clearly a voided type of a situation if that's what you're trying to disclaim any warranties, right? All right, there used to be this old term called privity. Privity means both parties were in that relationship. For example, say I go to Home Depot and I want to buy a Honda lawnmower from Home Depot. I am in privity with Home Depot because Home Depot and I made an agreement. I'm going to buy this Honda lawnmower for $500, right? We're both right there. We both agree. We are in privity. The old rule used to be since I bought the Honda lawnmower, could only sue Home Depot if there was any breach of warranty, right, in that situation. Under UCC, that has changed. In personal injury cases, most states no longer require that privity. I could sue Honda directly if I was injured by using their particular product. Even though Honda never agreed to sell me that particular lawnmower, I could still sue them directly if I was injured as a result of that, right? There used to be this old thing called economist lock doctrine. You do need to know that, and you do need to know what privity means. But in the basic sense of we are in privity if you and I were in direct people in the contract, right? That's what's called privity. Whereas we're not in privity in that situation where we weren't part of it, but I can still potentially sue you if I'm a consumer because you put that good in the marketplace. The economic loss doctrine was when an injury is purely economic and arises from a contract made by two businesses, the injured party may only sue under the UCC. That still generally applies. However, if the seller is a consumer, again, most states do not require privity to sue for breach of warranty. Again, this is still under privity type of scenario. All right, buyer's misuse generally preclude any warranty claim, right? If you remember when Michael's frying up his bacon, it would be difficult for him to sue Foreman Company because of his injuries, because he really misused, right? It was never intended that the bacon be fried right next to his bed where he could step on it, type of a situation. That would be a buyer's misuse. All right. Moving to Chapter 23, Performance and Remedies for Lack of Performance. Reminder, this is essentially, again, contract law, but the UCC has some of its own remedies. So remember what you learned in the last chapters about contracts, right? You don't have to remember for the test, but the ideas are the same. They're one and the same. Just UCC just kind of tweaks it a little bit here and there. But the concept, the idea of what a remedy is, right? There's a breach of contract, and therefore I'm going to sue for a remedy, is still the same idea. All right. Reminder, duty of good faith always applies, even in the UCC. Good faith means honesty and fact. These are important because here's where the UCC sometimes makes some differences depending on who the people are involved in the contract. Between merchants, it also means the use of reasonable commercial standards of fair dealings, right? So it means not only am I going to be good faith and be honest in our dealings, it also means I'm going to be at the levels of reasonable commercial standards of care, those kind of things. I'm going to deal at that what a reasonable industry standard. So if I go less than that, I could be sued for breach of contract, and the argument would be, well, they didn't meet reasonable commercial standards as they're required to do. So here are sellers' rights and obligations under the UCC as far as performance, and then what the remedies may be if they were not. I have to tender the goods, right? I need to make sure I give you the goods which you wanted, or that you did, in fact, buy from me, right? Sometimes it's immediate. I'm at Home Depot buying that Honda lawnmower, right? I'm the one that had to wheel it up there on the little cart. I make the deal with Home Depot to buy that Honda, and I'm out. So they've tendered, Home Depot has tendered that good immediately. Sometimes, though, the tendering of those goods may be in the future, right? Delivery in 30 days, 45 days, 60 days, whatever it may be, right? But I have to, as a seller, tender those goods in order to perform under a contract. And the conforming goods, not only do I tender the goods have to be conforming goods and making sure they're available at a reasonable time, right? That's part of the tendering of the goods. Secondly, keep the conforming goods available for a reasonable period, right? If you're supposed to come get them from me, we've agreed, I'm going to agree to sell you 100 widgets, and I have to agree to keep them, right? You can't take them immediately. You're going to bring a delivery truck to come pick them up, right? And 30 days is a reasonable standard. I have to wait at least 30 days for you, probably a little day or two here and there for the courts would be more appreciated for the courts, right? But I got to keep those conforming goods available for a reasonable period. And then deliver to the buyer any documents that needs to take possession of the conforming goods, right? Any of those title type of situations, bills of lading, whatever it may be, whatever documents they need, those would need to be handed over at the same time. All right. Perfect tender rule. The buyer may reject the goods if they fail in any respect to conform to the contract, right? The idea is I agreed to, say we'll go back to our Toyo tires. I'm agreeing to sell 100 Toyo tires to Les Schwab, right? So Les Schwab gets those tires, and they examine those 100 tires. It turns out 2 of those tires aren't any good. I can reject those 2 goods because they're not conforming goods. There's some defect in them that I noticed, right? So I can reject those 2 goods. I can't necessarily reject all of them. I can reject those particular 2 unless we had in our contract that it had to be perfect. If not, I could reject all. Right? But generally, only reject those that are non-conforming goods. Restrictions on the perfect tender rule. In other words, the courts are going to ignore the perfect tender rule. Perfect tender rule, I did a horrible job, and I apologize. The perfect tender rule is I'm agreeing that the 100 tires I'm selling to you, Les Schwab, are going to be perfect. They're going to be exactly for their intended use. All right, here's what the court's going to do, some restrictions on that. Uses of trade. Any practice that members of an industry to be part of their dealing. So say, for example, we understand that 100 tires, in that 100 tires, 1 or 2 of those is always going to be a non-conforming. That's just the way the industry works, right? Then our contract's still valid, everything's all good. I still reject those. I don't have to pay for those 2. I send them back to you, whatever it may be. But you've essentially complied. A substantial type of performance is essentially what the court is saying in that scenario, right? So if the uses of trade allows for a little bit of leeway here and there, you see that sometimes in sort of like car parts or whatever. There are certain specifications, right? But there's a leeway in what those specifications are. Instead of 0.5, maybe it's 0.6 to a range of 0.3 to 0.7 or something like that, right? Course of dealing. So in our life between Les Schwab and Toyo, over the years, there's always been an allowance of 2 or 3 tires, right, in that situation. Well, now, all of a sudden, Les Schwab couldn't come back and say, well, you didn't give me 100 perfect tires, therefore I reject all these tires and I'm sending them back to you and you're in breach, that type of a situation, right? Toyota tires come, look, courts, we've always been allowed to have a 1 or 2 or 3 types of tires that didn't conform. We were shocked and they didn't tell us, and so we shouldn't be held in breach, and the court's probably going to go along with them. Similar to course of dealings, but usually involves a single contract with multiple deliveries of same goods over that period of time, right? So, for example, I've contracted the tire scenario, right? But it's a 1-year contract in which I'm agreeing to sell 1,000 tires to Les Schwab, and then the first 7, 8, 9 deliveries of those tires, there's that again 2 to 3 variants of non-perfect or goods, right? Non-conforming goods is the technical term, and all of a sudden, the second 6 months, all of a sudden you start to get nitpicky on, right? Well, then we could come back and say, look, they're allowing it here. They can't all of a sudden turn around and say no more, right? And the court's going to say, yeah, you pretty much kind of set that standard, Les Schwab, so you're kind of out on that. Parties can agree on a level of non-conforming goods, even if within that level, buyer must accept those goods. Right, the cure. Now, here's again, we're getting back to the perfect tender rule. If I know, you tell me, hey, I got 2 tires that aren't any good here. I need you, in order to comply, send me 2 good tires, and you need to do so before X amount of time, right? Usually what our delivery date may have been, or within a reasonable time of that delivery date, right? So if the buyer rejects the non-conforming goods, the seller has a right to cure by delivering conforming goods within the contract deadline. Sometimes you may not want to wait till the last day because they reject them. You have time to cure that and bring in conforming goods. That's a cure under the perfect tender rule. Restrictions on the perfect tender rule, again, courts are generally going to ignore, and I've already talked about this a little bit, a substantial impairment in situations where buyers rejecting goods because of a defect. Buyer must show that those defects substantially impair their value. Again, if the specifications were off 0.1, 0.2 or whatever, but it clearly would perform exactly the way it was intended to perform, then you're going to lose in this situation here. You're not going to be able to prove that that defect, although it was defect, you agreed that it was going to be 0.5 whatever, and clearly is off of 0.5. It's a defect in what we agreed to. unless the substantially impairs what was intended to be used for, you're not going to be able to win in that situation. All right. Here's a different situation of the UCC where the goods themselves have been destroyed. If the identified goods are totally destroyed before risk passes to the buyer, the contract is void. Right? This is a situation where, say, the ship gets lost at sea, right? And at the time, there was never an actual transition to the buyer, the risk involved to the buyer, because you may have contracted that says, we'll deliver these to you, but you agree that once shipped from the place that you're reliable to us, right? Well, if that particular case, that situation, the risk has already shifted to the buyer. But if they haven't shifted to the buyer, the goods are destroyed, then the contract in that particular case is void. So if it's lost at sea, you couldn't, well, you were required to, yeah, but my ship is lost at sea. The court's going to say, yeah, that was a destruction of those goods. That contract is now void. If identified goods are partially destroyed before risk passes to buyer, again, buyer can accept those partial goods, or they can void out that contract. Basically, it's voidable to the buyer. Buyer can say, I'm going to buy these. They, it could be a discount value or whatever. Don't get me wrong. They're not buying exactly what it is, but they can say, yeah, I'll take these even though there's some partial destruction of those items. Seller is not responsible when destruction was not the seller's fault. Commercial impracticability. Commercial practicability is the idea that it no longer is it appropriate for this contract to go forward. There was, I think I've talked about it in the past, where the law changes, and as a result of that, we can no longer go forward with that particular. That's a commercial impracticability, right? Some supervening event causes performance of excuses the performance of a contract. If that event was within the parties' contemplation when the agreement was waived, if the event was not within the thoughts of the parties, right? In that situation there, then the contract is void. All right, again, there's a chart in the book for you to take a look at, what those different obligations are. All right, buyer's rights and obligations, right? Now we've shifted. Those were all the seller's rights and their obligations. Now we're moving to the buyer's rights and obligations. Generally, they're right? 1 to 10 of the goods, and 1 is to accept the goods, right? That's kind of how it works under the UCC. The primary obligation is to accept conforming goods and pay for them, right? That's generally what it is. Under the contract, you've agreed to buy X amount of items, right? Toyo tires, Les Schwab agreed to buy 100 Toyo tires. Their obligation then is to accept those conforming tires and to pay for those conforming tires. If there was 2 that weren't conforming, they're still agreeing to pay for 98 tires and to accept those goods. They can't object to all of them. That may include providing a location for delivery or an adequate place to pick up those goods. In other words, you can't let Schwab try to hide the ball, say, we want you we're going to purchase 100 and you need to deliver it within 30 days, but you don't tell them where to deliver it or anything like that, right? Inspection and acceptance, right? In addition to obviously paying for those items, if they're conforming goods, in order to determine if they're conforming goods, it's your requirement to inspect them. If you don't inspect them and it turns out later on that they're non-conforming goods, it's on you, right? Your at the time is to inspect them and then to accept them. If not, advise seller of any non-conforming goods. Buyer generally has a right to inspect within a reasonable time before acceptance. In other words, you can't just drop them off and then leave, and then they're like, yeah, you've now officially accepted those. Now, if it's 100 boxes, 200 boxes, they have within a reasonable time period, say 5 days, whatever it may be, to inspect those 100 boxes, make sure they're all conforming goods, and to inform the seller that they are, in fact, conforming or non-conforming goods. If a buyer chooses to partially accept, so long as the goods are sold in some sort of a commercial unit, they can do so for 100 boxes, right? But clearly, 2 of the boxes have been destroyed, right? I can still choose that 98 of the boxes. That's a box would be a commercial unit in this particular case here. So I can agree, although it's not the 100, I can still agree that this is fine. Revocation. It's the same as we've talked about before. A buyer can revoke acceptance only if they are non-conforming goods and that non-conformity substantially impairs the value of the goods, and only if they had a valid reason for the initial acceptance. In other words, they originally kind of took a look at them, they accepted them, and then later on they realized all the above there. Then they can revoke their original acceptance in that particular case. A rejection. Buyer must notify the seller within a reasonable time if they're rejecting any of the goods because they've determined during their inspection that they were non-conforming goods. Has to be within a reasonable time. The idea of that is to allow a potential for the seller to cure those non-conforming goods. In installment contracts, non-conforming types of situations, a cure may not be available in that situation, right? Or if a cure is not available, that's really kind of where you'll have a situation where in installment contracts, again, are every 30 days you're going to be producing. We've agreed on 1,000, but every 30 days you're going to give me 100, right? Or whatever, 1,200, I guess that would be type of a situation. That would be an installment type of a contract. If those non-conforming goods here and there, right, you can reject in part, but you're not rejecting in total. But you can have a situation where you're saying these ones were non-conforming, you need to reject those, and the next shipment is conforming, right? In a installment contract, each installment is what you're going to have to inspect, right? Again, continue with the seller's remedies. They can stop delivering. If the buyer breaches before delivery, seller can refuse to deliver, right? These are the seller's remedies when the buyer is somehow found to be in breach of contract. So if the buyer breaches before, maybe it's anticipatory breach, they said, I don't want, or you know they've gone out of business or whatever, right? You can refuse to deliver because you don't want to do the cost. In some instances, you have a duty to mitigate. If you knew that they weren't going to accept and you're going to ship them across country, it's going to cost you $1,000 to deliver them. To save that $1,000 in delivery, you may have to make sure you don't deliver them in order to mitigate. Right? But if a buyer breaches before delivery, seller can refuse to do the delivery. Repudiation, the party's indication that it will not perform, right? In that particular case, we've talked about it before. If the buyer were to repudiate, and maybe there's economic reasons for doing so, then I can stop delivery if I am the seller of that, right? It's a party's indication that it's not going to. I'm not going to accept your goods, and I'm not going to pay you for your goods. So don't send them to me, right? It can be done expressly or by conduct or by refusing to answer a written demand of assurances that you are going to perform. So in other words, before I go and send out my truck to deliver those and that expense of $1,000, I said, hey, do you still intend to accept these goods when I deliver them to you? And you say, or you don't answer at all. You say, no, then clearly I don't have to do so. You don't answer at all. Then you have a repudiation in that situation. All right. Identify goods to contract. If a seller learns of a buyer's breach, seller can identify, kind of mark, label, set them aside. And this happens more often than you think. And those makes it easier later on to determine, right, because for example, I may have a duty to mitigate. So those items that I mark, say it's those tires, and I've marked these were the tires that Les Schwab is going to purchase from us for $100, I think it was $50 a tire, right? So $50 a tire, right? I marking those, and then it's my duty to mitigate. I sell 80 of those, so there's only 20 tires left. But maybe I sold them at a reduced price. Instead of the 50, I sold them at 40. But we clearly have 20, right, that Les Schwab is required to have paid or they're in breach of contract that were $50. And then I have the other 80 that I'd mitigated. It's only $10 difference, but because I clearly marked them, it's easier to determine when I sell them later on how much I sold them for, and therefore to determine what damages, the economic damages would be. All right. That's why identify the goods helps in a lot of ways for later on. Resale. A seller may, in some cases, and this is that we talked about duty to mitigate, sell those goods and doing so to recover some of their losses, right? They have to sell it a commercially reasonable manner, right? You can't do a sort of brother-in-law deal to somebody and then turn around and try to, screw over the Les Schwab type of situation. And usually what happens is damages equals the contract price, right, the $50, minus the resale price. Remember, we sold some of them for $40. If it cost me anything to deliver them or whatever that may have been, any of those types, I get those as well. And then any expenses that were saved. Maybe I was supposed to deliver those and instead somebody came by and picked them up and from me directly, so I actually saved some money, right? That's kind of how damages are done. If there's no resale or non-commercially reasonable resale, then that's how the court's going to determine damages. You don't need to know these formulas, but they're helpful to understand. Right? Oh, sorry, I went too far there. All right, again, continuing on with seller's remedies, we have what's called an action for the price. Now, the seller may recover the contract price, right, if the buyer has accepted the goods or the seller's goods are conforming and the seller is unable to resell after a reasonable effort. This can happen sometimes when it comes to perishable goods. Say it was 100 bushel of apples, right? I delivered them to you. You accepted those, and then you never paid me for them. And a month goes by, I can't sell them at that point in time, right? Nobody wants those now bad apples because they're all molded and bruised and whatever. So I'm going to be able to get from the buyer, the entire price of our contract. All right, buyer's remedies. Now, if the seller fails to deliver goods, or if the buyer rightfully rejects the goods, right, they're non-conforming, then the buyer can cancel the contract, can recover any of the money paid, and seek any of these types of damages that we're going to talk about below. What's called cover. Say I really needed those apples that you were supposed to deliver to me, right? I make apple cider, and I have contracts with other folks. You were going to sell me a bushel of apples for $5 a bushel, right? I can cover by going out and finding, and maybe I have to pay $7 because that's all the market's out there. Maybe that's the reason why you decided not to sell to me, is you knew you could potentially make more money by $10. Somebody's willing to pay you $10, right? So that'll cover whatever you're going to make, plus you get more of a profit. Whatever. It cost me $7. I can sue you for that $2 difference is what the cover means, right? Reasonably obtaining similar or substitute goods is what a cover is. Again, damages are essentially whatever a contract price plus whatever it cost me to get those covered goods. Non-delivery. Buyer doesn't cover or reasonably cover in that situation, right? That's pretty much self-explanatory. Again, damages are market value minus contract price, all there. Again, you don't need to know the formulas. It's just helpful to understand kind of how the courts will do so. Acceptance of non-conforming goods. Buyer can accept goods but notify seller that the goods are non-conforming. So you can still say, look, I'm going to hold on to these. They're non-conforming goods. You can either remedy by a cover, right? Give me conforming goods within X amount of time. Or I'm going to try to resell these, but I may sue you for the difference of what a conforming good would have been versus a non-conforming good type of situation. Those are the damages and how the court would assess them. Specific performance. Remember, this generally involves a very specific, one-of-a-kind item. Again, it's still the buyer can sue to make the seller give them that particular good, right? Right, that's the end of this particular presentation. For our next section, I'll get it posted for you guys here pretty soon. So thank you for, again, your patience with me, and reminders that you have your extra credit paper due before our first test, and you need to get your essay in, as your ethics essay in as well, and make sure you have any and all other assignments in to me. There's not going to be much of a participation grade, and obviously we don't have mock trial grades for that. Everybody's still doing very well on the class, and I'm obviously going to give you guys a lot of latitude. Stay safe. Take care.